Greetings. I'm Dr. John Jiggens. Many of you know me as an activist in the Assange campaign. Tonight, we end the Assange campaign in Brisbane because Julian Assange is free. He is free because of you. He is free because of me. He is free because of his father, John Shipton, who is with us tonight. The Assange campaign needs to be no more. Tonight we're rebranding ourselves as Truth Not War. On our new banner there is a quote from Julian Assange. If wars can be started by lies, then peace can be started by truth. War is theft. War is murder. War is rape. It is the breaking of every moral commandment that makes civilization possible. So it is necessary to lie about war. The first casualty of war is truth. Julian Assange was a casualty of truth. David McBride is a casualty of truth. He has been sentenced to 5 years and 8 months for telling the truth. Today marks his 175th day as a prisoner. He has 2,000 more days to serve. To tell the story of David McBride, we have assembled an impressive line of speakers. Professor A.J. Brown, Chair of Transparency International Australia, Michael Cope, President of the Queensland Council of Civil Liberties, and John Shipton, the father of Julian Assange. Our MC for the night is Imogen Bunting. So welcome her with applause.
Good evening, thank you. So tonight I think we'll start with a very, very quick welcome to country. So I'd like to acknowledge that this meeting is being held on the traditional lands of the Turrbal and Jagera peoples, and that this land was never ceded, and to pay respects to elders, all past, present and emerging, and welcome everyone here this evening. So tonight is about supporting David McBride, but not only David McBride, because David is not the only whistleblower that is facing trial after blowing the whistle. There is also Richard Boyle, who asked serious questions of the tax system, and many others. There's a lady who blew the whistle on the trucking industry recently, Roxanne Mysco. And as recently as 2 days ago, ABC published a story headlining that construction insiders fear speaking out against the CFMEU without whistleblower protections. So, a little bit about me. I assisted as I could with the Assange campaign to free Julian and have ridden the waves of events surrounding him as these unfolded and affected his life around the world. I'm currently enrolled in a Bachelor of Laws with honours and a Bachelor of Criminology and Criminal Justice. It seems to me that perhaps I am to be a forever student. I have experienced many years of hardships and come to my interest and understanding of these issues from a grounded experience in not only economic but also of systemic disadvantage. It appears true that without a groundswell of support and people brave enough to speak out against abusive systems, that change doesn't occur. Tonight is about whistleblowers, and these come from all walks of life and many areas of expertise. Supporting better starts with supporting those we can see are working for better. Thank you everyone for being here. I am also truly honoured to be emceeing this event and to be surrounded by such good people as yourselves. So thank you for having me. So John Jiggens has just introduced the event, and he's representing Truth Not War, along with Jenny Lewington, who is, she's been publishing the Assange newsletter for many, many years. She's a lady in the wheelchair at the back of the room, an incredible activist. Tonight's speakers, as John said, are extremely impressive. We've got Mr. Michael Cope here in the middle. Michael's had a long-standing interest in civil liberties issues and has been active in the Council and other human rights-related organisations. He's the current president, as John said, of the Queensland Council for Civil Liberties and has held this office since March 2005. Mr. Michael Cope commenced his legal career at a Brisbane legal firm specialising in criminal law and assisted representing the Queensland Police Union before the Fitzgerald inquiry. He also volunteered at the Caxton Legal Centre for 3 decades, for which, in my books, he forever deserves commendations. These days he practices in commercial litigation, mainly building disputes. So the second speaker tonight is Professor AJ Brown. Lovely man just here. He's the chair of Transparency International Australia, the World Anti-Corruption Organisation, having served there since 2010 on their board of directors and from 2017 to 2022 on the global board. In 2019 to 2020, he led the development of Transparency International's worldwide strategy, Holding Power to Account, from 2021 to 2030. So we're still in the scope of that report. In 2023, he was made a member of the Order of Australia for services to the law and to public policy, particularly through whistleblower protections. Professor AJ Brown is a Professor of Public Policy and Law in the School of Government and International Relations at Griffith University, where he specialises in public integrity, accountability, governance, reform and public trust. He appears to have taken a lifelong commitment to education very seriously and currently sits before us holding multiple degrees, a Doctor of Philosophy, a Bachelor of Laws, a graduate diploma, which he does tell me is not a degree, but it's a graduate diploma of legal practice and a Bachelor of Arts. So we have a highly esteemed panel. And of course we've got Mr. John Shipton, Julian Assange's father, who I don't think needs much introduction to the room, but is one of the best people I know. Before I allow any of these fine gentlemen to speak, though, I have a bit of a statement from Eddie Lloyd, who isn't here this evening. Eddie Lloyd is David McBride's lawyer, for those who aren't aware of that. And she has asked me on behalf of David and herself to just give you this update. David said thank you so much for organising the event. He's keeping himself busy, but jail is not a nice place at all. Correctives randomly raided his room last week like rock stars trash hotel rooms, throwing every item in his room upside down and inside out, emptying washing powder all over the floor and leaving everything there for him to clean up. Whilst they raided, he was taken to a small holding cell for the whole day. Of course they didn't find anything, but another inmate had a phone and was taken to segregation for punishment. And we know that if they wanted to find something, they perhaps might plant it too. So it's a terrifying place to be. These random raids are very destabilising and are a stark reminder to him that he is a prisoner, a political prisoner. He is comforted by the regular flow of letters and postcards. The other stressful part of his life is that we might have to pull the appeal because we have not raised enough funds to pay for the barristers. Eddie is a pro bono and the 2 barristers are doing heavily reduced rates, but they still need to be paid. Basic expenses need to be covered. So having done everything we can to raise funds, but with the appeal only 5 months away, it's getting very, very close to the point of letting go of the barristers as we can't retain them if there's no likely way to pay them. So obviously this is also a fundraiser and we're hoping that David's appeal can be funded. And if you know anyone that might be likely to support him, to encourage them to do so. Besides that, David remains proud of his decision and would not do anything differently. He hopes that his incarceration shows the public of the dangers of speaking truth to power and the need for whistleblower protections. He asked if I could specify specifically the following. David welcomes the Whistleblower Authority Bill that Senator Pocock and the crossbench wishes to introduce. However, and he asks this be emphasised, the Whistleblower Authority would not assist him, nor Richard Boyle. The support the Whistleblower Authority would give whistleblowers who are negotiating the process is a positive, but please be aware that the problem is with the whistleblower laws in the Public Interest Disclosure Act, because the Act prohibits protection for whistleblowers like David who have national security information. It's frightening given the national security whistleblowers are potentially the most important whistleblowers. These are government whistleblowers. By refusing to protect them and instead jailing them, the government is sending the public a chilling message. If you speak truth to power, we will silence you. As David sits in jail for the next couple of years, he asks the public to speak for him, as he has been silenced. He asks the public to make some noise and campaign to fix the PID Act, so the next David McBride is not silenced. Richard Boyle is the other whistleblower currently being silenced because the PID Act does not protect him either, because it won't protect whistleblowers if they gather evidence before they blow the whistle. Because gathering evidence, also called preparatory acts, is unlawful. In practical terms, this means you can blow the whistle and talk about what you saw and read and want to expose, but you won't get far because you have no evidence to prove it. A common feature of the whistleblower experience is that after they blow the whistle, there is almost always a targeted campaign on them by their employers to discredit them. An obvious way to make sure that any evidence that might have existed will quickly disappear. The Public Interest Disclosure Act is a farce. Since its inception in 2013, 11 years ago now, not one whistleblower has been given protection by the Act. So whilst a whistleblower authority is needed, David asks that the public focus any campaign efforts on demanding the government reform the Public Interest Disclosure Act, first and foremost, to protect national security whistleblowers and to protect all whistleblowers so that they can collect evidence essential to exposing wrongdoing. The Public Interest Disclosure Act went out for consultation and we are still waiting for the Attorney General to announce what reforms he will accept, including submissions made about protecting national security whistleblowers and preparatory acts of whistleblowers. So that's why it is vital that campaign efforts are targeted to reforming the Public Interest Disclosure Act, as well as strengthening protections through the Whistleblower Authority. So, that all said, thank you, Eddie, for that. We'll move to Michael Cope.
Yes, hello everyone. On behalf of the Council for Civil Liberties, I thank John Jiggens and the organisers of this event for the invitation to speak tonight, and I acknowledge the traditional owners of the land upon which we meet. The theme of tonight's discussion is whistleblowing. I want to discuss the decision in the McBride case in the context of the international jurisprudence concerning command responsibility as it has developed since World War II and in particular the Nuremberg trials. And yes, I will come back to whistleblowing and its connection with that in a moment. Many people have framed this case in the context of the Nuremberg rejection of the principle of superior orders. That is, the idea that if you are a subordinate in the military and you act in accordance with superior orders, you are not criminally liable. But that is not, in fact, the current absolute position in international law. In fact, a subordinate is entitled to obey orders and will not be held criminally liable unless those orders are manifestly illegal. David McBride argued something completely different from that. He said that as an officer of the armed forces, he had a duty not only to obey orders, but to the public interest, which in that case was the public interest in the exposure of possible crimes by members of the armed services. What I want to suggest is that part of the international jurisprudence that the court in that case ignored is not that about superior orders, but the duty on commanders to prevent war crimes, generally referred to as the duty to prevent. That duty has been formulated differently by different international tribunals. But before I talk about that, I want to issue three caveats. The first caveat is that I am not an expert in this area of law. In fact, as Imogen explained, my daily legal practice involves building disputes. Secondly, there are a number of aspects of the duty to prevent which would be of concern, and if we ever got to talk about it, to civil libertarians. Because, first of all, some versions of it say that commanders are criminally liable for mere negligence. Secondly, it imposes a duty on someone to do something. Once again, in ordinary common law concepts, that is not the way the criminal law operates. And finally, it makes, probably the reverse of what I've just said, it makes people criminally liable for omissions. In fact, I've got that slightly wrong. The second aspect is that it makes people liable for somebody else's acts, which is not something that criminal law does. And the last one, as I said, is that it makes people criminally liable for their omissions. Of course, the contrary argument that military commanders are in a different position. They have enormous power. As I've already noted, their subordinates are obliged to obey, and if they don't, they are themselves liable. They are in a position to make life and death decisions. And this is a position that they have accepted voluntarily. Now, whether those arguments contradict the normal civil libertarians' concerns about making people liable in all those other circumstances is a matter of debate. The third caveat is that it will no doubt be said that McBride was not in a position of command responsibility, which he clearly was not. But it seems to me that if the arguments which justify an obligation on direct commanders to prevent war crimes apply, they must also apply to others who become aware of such conduct. None of this was discussed by Justice Mossop of the ACT Supreme Court in his decision in the McBride case. He was particularly influenced by an 1869 book by a chap called Claude, if I'm pronouncing his right name correctly, called Military Forces of the Crown, where he said a number of things which the judge was highly influenced by. In the first place, he, by which he means a soldier, is bound to obey and to give his personal service to the Crown under punishments imposed upon him for disobedience by the Mutiny Act and the Articles of War. No other obligation must be put in competition with this. Neither parental authority, nor religious scruples, nor personal safety, nor pecuniary advantages from other service. All of the duties of his life are according to the theory of military obedience, absorbed in that one duty of obeying the command of the officers set over him. He also said, and the judge quoted, "Obedience must be implicitly exacted by each responsible officer, for nothing can be more dangerous than to allow the obligations to obey a law to depend upon the opinion entertained by individuals of its propriety, and in military affairs it would be intolerable." The judge also accepted, as a justification for his decision, Commonwealth concerns that a soldier disclosing information would damage Australia's standing with foreign partners. This is the good old thing that people always trot out. I've never seen any evidence to support it, and as probably some of you will have noticed, quite often the Australian government is embarrassed by the fact that some American public servant stands up and says something which the Australian government has refused to tell people on a regular basis. It doesn't seem to stop the Americans from talking to us and vice versa. Contrary to what Claude, or however his name is pronounced, and despite concerns about foreign relations, international law has concluded that there are times when a public duty trumps the narrow dictates of a lawful command, notably when it comes to the commission or concealment of crimes. International courts and tribunals have recognised that the fact that a commander fails to address earlier known conduct may be seen as acceptance or encouragement and may serve to increase the risk of future crimes. and that is what the duty to prevent is at least part based on. There are also pragmatic considerations. If you fail to punish bad deeds, that will of course encourage subordinates to behave badly. Unaddressed misconduct can nurture an atmosphere of lawfulness. People may become members of the armed forces, may come to believe that bad behaviour is what leads to success in battle. But the jurisprudence about this is couched in more broad terms, less utilitarian terms, and recognise that this rule is essential to ensuring that soldiers uphold the standards of conduct and obey the humanitarian precepts of international law. The result is that many states have got together and agreed that commanders have duty under international law to prevent, suppress and punish crimes by their subordinates, and to monitor and properly supervise and control their troops. If commanders fail in this duty, then serious crimes and violations of fundamental rights and freedoms can result. This is in fact reflected in the 1949 Geneva Conventions. Reflecting on the relevant provision of that convention, the International Criminal Tribunal for the former Yugoslavia held that under the relevant article, it is sufficient to make a commander liable if the commander has received general information that would put the commander on notice that further inquiry or additional investigation is required to determine whether offences were committed or about to be committed by their subordinates. The Rome Statute establishing the International Criminal Court also has a duty on commanders to prevent the commission of crimes. And under that statute, arguably, on the basis of some decisions, it sets a lower standard for command liability, as it requires only a subjective awareness that something is going on, as opposed to possessing actual, although general information that puts the commander on notice of the need to investigate further. These principles are in fact reflected in Australian law. They are contained, if you want to know the details, in section 268.115 of the Criminal Code, Commonwealth. And an argument was put to the Brereton inquiry, which was of course set up following the revelations of David McBride, that the SAS commanders should have been prosecuted under this law. The Brereton report acknowledged that there was some information regarding potential crimes. Namely, local Afghans had told Australian forces that unlawful killings were occurring. There were persistent rumours of unlawful conduct. There was a prevalent use of suspicious boilerplate language in operational reports. And there was a suspicion, if not acknowledged at troop and possibly squadron level, of the unlawful practice of carrying throwdowns. And throwdowns are basically you take some weapons off the locals, you keep them in your backpack, and when somebody's killed, you throw them down and say, okay, these people had these things. There might be guns, they might be radios, they might be anything. To which you can say that they were with the enemy. The Brereton report, in response to all of this, basically accepted the alternative explanations, which were that it was just propaganda, or it was motivated by a desire to claim compensation, or the use of throwdowns was for avoiding questions rather than concealing unlawful killings. Like many commentators, I was not very impressed by these findings. It seems to me, along with those, that if a commander knew some or all of the things that I've just described, they may well have been liable because, as I've just said, they must have known that something was going on. So, in the context of all of this, and coming back to tonight's topic, we need to reform Australia's whistleblower laws. Now, A.J. Brown is going to talk about the Wilson report in the context of Queensland, but I want to discuss what we need to do about Australian whistleblower laws. And I acknowledge Imogen's comments about how inadequate they are. The whole concept of these laws is to provide for a process by which people who want to make a disclosure can do so in accordance with those rules, and they get protected. And we in the Council for Civil Liberties would accept that there are some secrets the government is entitled to keep, at least on a time-limited basis, because it seems to me that most things, secrets lose their value after a period of time. And the whole idea of these laws is that people should not disclose things that are really actually going to harm people or important government interests. So how do we deal with those people who legitimately do not want to go through that process? And what we argue is, particularly in the context of the military, where of course you've got a whole culture of group solidarity, people who go outside the group are looked down upon and subject to reprisals for what they do. How do we deal with those situations? And the model that we have put forward involves two levels. At the first level is accepting, as we do, that there are some secrets governments are entitled to keep, that if you want to go outside the disclosure regime, you do run the risk of ordinary disciplinary processes, including dismissal from your job, except where what you do is to disclose a frankly illegal conduct. But when it comes to people like David McBride, who are to be prosecuted criminally or subject to civil penalties, then they should be entitled to a protection. The government, in order to impose serious penalties, such as prison or other serious penalties, the government should be required to prove that the discloser lacked a reasonable basis for believing that the public interest in disclosure outweighed the identifiable harms to the public interest which might flow from the disclosure. In the case of other less serious penalties, which might be available outside disciplinary process, a lesser penalty is proposed, being that the government must show that the disclosure lacked an objectively substantial basis for believing the public interest in disclosure outweighed any identifiable harms to the public interest that might flow from the disclosure. So those laws would give a broad range for people who don't want to go through the process. And of course in the military, one would think you would be particularly not interested in going through the internal process, to make disclosures and to be protected from the worst possible outcomes, which of course is what's happened to David McBride. This type of law, of course, should be available not only to the military, because quite simply, and this is why we're all here today, we cannot have a situation where somebody is thrown to jail for almost 6 years for exposing killings and other gross violations of human rights. It's simply unacceptable, and we need to do something to fix that. Thank you.
You're up, Mrs. Brown. Yep.
Excellent.
One you can hold, or you have to the mic.
All good, all good. Thank you very much, Imogen, and thanks very much, Michael, as well. And yeah, it's a great pleasure to be with you, to continue to lend my voice, our voice, to explaining why David McBride's incarceration in the Alexander McConaughey Centre in Canberra is such an injustice, but also what people can do about it, which is really, really important. It's great to have followed on Michael's explanation of some of those fundamental principles, because David McBride, who a few of you would have met, quite a few of you would have met David, at one or two events where he's been speaking in favour of truth and justice, and also for the freedom of Julian Assange, then you'll know a little bit about what David is like. And the key thing is that everything that Michael said is very, very relevant, because David's disclosures, not just in the end what drove him to provide information to the ABC, which helped blow open the Afghan files and people's awareness of what was going on in the Brereton inquiry and with war crimes in Afghanistan, but also his internal disclosures. One of the key reasons why David's conviction and incarceration is such an injustice is that David did try and follow the rules. He did make disclosures within defence, and those disclosures were not necessarily so much about the fact that there were war crimes, but about exactly what Michael was saying about the responsibility of the management of the Australian Defence Force, and indeed of the government, for the environment that actually made it relatively predictable that there would be problems in the campaign and that things like war crimes would occur. So his disclosures were very much about the injustices of the way in which that resulted from the way in which the Afghan campaign was managed, and the failure of management responsibility in defence, and indeed the way that the government was managing the overall war, that meant that, as he's put it, he probably put it to you, has put it to me, is that people who were not heroes were treated as heroes, people who were not villains in that environment but were caught up in wrongdoing were vilified and treated unfairly, because they in fact were the product of an environment and a way in which the war was being managed that meant that they weren't being treated fairly, even when they were sort of complicit or arguably complicit in some of the consequences of the way that war was run. So that's what he was. His disclosures were very complex, but they were legitimate disclosures about management responsibility and failures, and about the injustices of the military justice system resulting from the way in which the Afghan war was run, which produced the war crimes, or the alleged war crimes. So it's a real injustice that David is in jail for having done that, for a number of reasons. And having visited David myself in jail since he became a guest of the ACT government at the Alexander McConaughey Centre, it's very sad to hear about what Imogen was reading out from Eddie about some of how he's faring. All I can say is when I met him, he was doing pretty well. It was good to see that his spirits were pretty strong, and that he definitely gets a lot out of letters and postcards and visits from people talking about the importance of these issues. The only good thing is that the Alexander McConaughey Centre in the ACT is a pretty modern, up-to-date jail. There are worse jails. Most people who have been involved in the law have been exposed to one or two jails in the course of their career. It's not a bad jail as jails go. That's the only thing that can be said about it, but it is still jail. So it really is important that people do support his appeal for a number of reasons, if only because the sentence that he was given was incredibly severe. So part of his appeal is against the severity of the sentence, and it was a very severe sentence, and there are good prospects, if that appeal goes ahead, that will make a real difference just in terms of the practicalities of him getting out, becoming eligible for parole much earlier, and just getting him back out of jail again, which is a crucial thing, the same way that just getting Julian home and out of incarceration was such an important thing. So please do consider encouraging people to support his appeal, and support it yourself if you can in terms of the legal costs. It definitely is an appeal that needs to be run. But putting aside the severity of the sentence, I think it is really important to reflect on how, as we've already been doing, on how the laws have produced this injustice. Because when we look at the injustice of David's incarceration, if we look at the injustice of the continuing prosecution of Richard Boyle from the Australian Taxation Office, and bad news yesterday that he lost his application to the High Court for special leave to appeal against a series of decisions that have meant that he's not eligible for a public interest defence either, and so he will be heading for trial. It really makes it very, very black and white how broken the law is, and so that's bad news. But it will make for a lot more momentum in terms of awareness of people of how broken the system is, because that will be another trial coming down the pipe that should not be happening, and that's a prosecution that is even more malicious and unjustified than the prosecution of David. But there are others, and so it is really important to reflect on how are these injustices happening, and it's especially important to reflect on why are these injustices happening when broadly across our society we do understand, most people do understand, most policymakers do understand how important whistleblowers are. And that's why we have laws that, at least symbolically or in theory, are meant to protect them. This is actually something that we accept as a society. We know it. People gathered here tonight are not a strange group of individuals for your support for whistleblowers. Most Australians actually support whistleblowers. They're built into our system of accountability. And it's especially important to reflect on this question of why are we then getting it so wrong when we've just been through the positive experience of Julian Assange coming home, because despite the bad precedent that his conviction sets and the fact that he was in the end effectively forced to plead guilty to any offence under US law and under the Espionage Act for what he did, there's no doubt that Julian's return, the deal that was done and his return, is a massive moral victory for disclosure, for transparency, and for the role of whistleblowing, which is what WikiLeaks and Julian set out to provide the most revolutionary vehicle for in the history of the modern world. And so the fact that in the end the deal was done and that Julian came home as a free person, and that so many policymakers and so many of us basically basked in the warm glow of satisfaction of this moral victory. And even those politicians like the Prime Minister, who was saying, well, you may or may not agree with what Julian Assange did and what WikiLeaks was and blah, 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 blah. You may or may not agree with that. We just brought him home because we do this for any incarcerated Australian overseas. Well, we know that's not quite right. And we know that there was an enormous amount of justified positive satisfaction about having brought Julian home, not only because he was an Australian who was being subjected to a far too long legal process that was unfair and unjust and unwarranted, etc., 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 but because of the fact that he was being subjected to that fundamentally for having done things that were quite revolutionary in the name of transparency and accountability. And there's no doubting that remains Julian's incredible legacy that will never change, even though I'm sure we haven't heard the last of Julian and his contributions to accountability. But it makes it all the more important to reflect on, hey, we've sort of demonstrated and reinforced to ourselves, and politicians have reinforced to ourselves, not every politician, but most, a lot, that actually transparency and accountability and the role of whistleblowing are important, and that's part of why we are happy that we've got Julian Assange back home, because it speaks to our values and what we know is important for democracy and healthy societies everywhere. And so we've come out on the right side of history, at least in terms of that moral victory, notwithstanding the bad precedent that conviction under US espionage law sets. Anyway, I'm sure John's got plenty more to say that is probably more accurate, reflecting back on all of that incredible history. And it's funny to have, I think one of the last people I visited prior to visiting David McBride in jail just earlier this year was actually 13 years ago or whatever. Was one of the last incarcerated people I ever visited was probably Julian when he was under house arrest in the UK. Way back in about 2012, I think. So I guess that's why we've got to be clear about the fact that the laws are broken, and that they need not be broken, and that they can be fixed. David's quite right in his message that he gave, that Imogen read out, that there are different components to fixing up the laws, and we really want people's support in all of these components. It's very true that the most recent development, which is one that we've been pushing for very strongly, was the announcement by independent and crossbench MPs at a federal government level that they would push ahead to introduce a private member's bill for a federal whistleblower protection authority. And that's only part of the matrix. And I think what David is saying is quite right. It can and should be an important part of the matrix of how things are fixed, particularly because one of the reasons why it should help prevent these kinds of injustices of prosecutions like this is that on the model that we've been advancing, and which is helping inform that private members bill, but which is also hopefully a bit of a no-brainer for when the government and the opposition come around to supporting the same thing, is that it would be an authority that not only provided practical support to whistleblowers and helped make sure that they got compensation where they do suffer for their experience, etc., but that it would act as a brake on attempts to prosecute or discipline whistleblowers, so that the decisions that are currently being made by agencies, in this case, in David McBride's case, the Defence Department and the Director of Public Prosecutions, those decisions to prosecute would have to go past the Whistleblower Protection Authority first to say, hang on a minute, what's your calculation of the public interest here? Before you can go ahead with this prosecution, you actually have to also satisfy us that it's meeting the public interest tests that some of which are the type that Michael was outlining. The same with Richard Boyle. In his case, there is no question that is a malicious prosecution, that the Australian Taxation Office had already sacked Richard Boyle for having made too many complaints about impropriety and maladministration within the tax office and the type of unjust tax enforcement practices that Richard objected to. So they'd already sacked him for making all of those complaints. And then because of the fact that he also then talked to journalists, which he was actually entitled to do, because of the mishandling of his internal disclosure, they're pursuing him with criminal offences. And when I've asked people in authority, people who know why is the tax office and the Director of Public Prosecutions pursuing someone with criminal offences for technical breaches of information management laws, in effect, which have done no harm to anybody, those technical breaches. Why are they doing it? Then the answer comes back because it's personal, And this is what happens with whistleblowers. We can all agree that whistleblowing is important. We can recognise its value, but as long as the people who are directly affected by the embarrassment or the problems that go with having made that disclosure, as long as they're in control of the responses to the whistleblowing, which is what continues to happen at the moment, then of course you will have the wrong people making the assessment as to what is or is not in the public interest. It's not objective, it's malicious. So how do we fix that? The reason why you should be very confident in your support for David McBride and his appeal and the fact that this is an injustice is that a number of things happened with his trial that really confirm how easily the current laws are being subverted. Anybody who blows the whistle who's a federal public servant or a federal officer in the military or whatever, they should not have to rely on the types of principles that Michael was talking about in order to be able to say, in my specific circumstances, the chain of command, does not apply, blah, 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 blah. All of them are meant to be entitled under the Public Interest Disclosure Act to a public interest defence. If what they've done is effectively blown the whistle in a responsible manner. Now that question of whether or not David actually blew the whistle publicly in a responsible manner never made it to court. He never had his fair day in court because of the fact that the Commonwealth ran the prosecution in a way which was actually intended to prevent the court from hearing some of the key things that would have made him eligible for that statutory public interest defence. One of those is the fact that he made prior disclosures internally, and they weren't. He never got the opportunity to argue that those disclosures were not properly dealt with, that he had reasonable grounds that they were not adequately dealt with. If he had been able to argue that, the fact that he'd made those disclosures, then he would have potentially been entitled to the statutory defence under the law. but the Commonwealth ran the prosecution in a way that that made sure that he could not effectively raise those internal disclosures, and used various loopholes under the way our law works to be able to write that out of the picture, so that he basically subverted having a Public Interest Disclosure Act or a whistleblower protection law in the first place. The other thing that went wrong is exactly that carve-out that David mentioned in his comment that Imogen read out, is that there's not a total carve-out for people with national security information. You can still be a national security or an intelligence whistleblower, and you are actually covered by the regime, but you will be treated differently and very differently, because the definition of what is intelligence information that you can't put in any disclosure, certainly not any public disclosure, is so massively wide that it's ridiculous in its breadth. And so there is a real problem with that particular piece of the carve-out of the law. Some of these problems are notorious problems in whistleblowing laws all around the world. We're not unique. There are some things about our whistleblowing laws that are still quite superior to other countries, but basically it's cases like this that just show that it doesn't matter how good they look on paper, comparatively they're not working and they're failing very, very seriously. So it really is important that you get behind David's message about the importance of reform of this process. His appeal is important, just if only on the severity issue itself. He's probably not going to be able to win on any in terms of overturning a conviction. We can try, but because of the bad state of the law, but it really is quite feasible to get the laws reformed so that they don't, so that these sorts of injustices don't happen again, both in terms of the technical preparatory breach offences that have been used against Richard Boyle in his malicious prosecution, and these types of loopholes in the federal law that apply to a whistleblower like David McBride. Just to put you in the picture, I mean, there are glimmers of hope, actually, because of the fact that the role of whistleblowing is so widely accepted. So we do have a federal government and indeed a coalition opposition at a federal level that is actually driving quite hard for meaningful reform, but we're waiting to see what direction that will take. But even just yesterday, you might have heard on the news there was a major parliamentary inquiry by the Parliamentary Joint Committee on Corporations that did a big investigation into the PwC scandal, the consulting firm scandal, and it's put a very strong weight behind a very comprehensive approach to sorting out our whistleblowing laws in order to fix all sorts of problems, including some of the ones that we're talking about. So if you want an easy reference for what needs to be fixed, which was given quite a lot of endorsement from that committee yesterday, then you only need to go on Transparency International Australia's website or the Human Rights Law Centre website, and you'll find our federal roadmap for law reform for protecting Australia's whistleblowers, which includes some points about David, some points about Richard, and you don't have to invent the agenda. The agenda is clear. We know what needs to be done. And so that's an important reference for people. Since then, we've also produced what is included in the roadmap, but which is also in a separate document, which is draft design principles for a federal whistleblower protection authority. So even though what David says is quite right, it in and of itself can't solve the problem without the actual protections being all fixed up as well. They're important parts of the component, important component parts of the answer. And so, again, you don't need to feel that you have to invent all of the answer. Quite a lot of us have been putting quite a lot of work into this for quite a while. You don't have to agree with everything we're proposing, but certainly a lot of those resources are there which make it crystal clear what needs to be done. So the question is really the momentum to do it. And just to give you another sort of glimmer of hope, I mean, there are a few glimmers of hope that we should put maximum pressure on the federal government to actually move ahead with comprehensive reform, which is seamless and effective to make sure these sorts of things can't happen. But even at a state level here, and Michael did mention that I was going to reference the state election here, just 2 days before the election, the incoming new government, the Christopher government, made very explicit commitments that it would do actually what the outgoing Labor government had not got around to doing yet, which was to follow through on major recommendations for reform for Queensland's state public sector whistleblowing law. There has been a recent major review of, in fact a number of them, of Queensland's whistleblower protection law. The last major review was conducted by a very distinguished former Supreme Court Judge Alan Wilson. That report's been sitting on the shelf for 16 months, and the incoming LNP government has committed to implement that report and to proceed with reform of Queensland's whistleblower protection laws. We hope that they'll go even further than that report and do a really good job of it. But it just goes to show that there are reasons to be optimistic that that reform can be achieved. It's really important to be mindful of the sacrifice that effectively is being demonstrated by people like David McBride or Richard Boyle that so clearly demonstrate and confirm why reform is so imperative. But in encouraging you to maintain your support, and particularly to support the appeal, David McBride's appeal, I think it's great to have, again, glimmers of hope. It's great to have the positive, the demonstration of the positive effect that the Assange campaign had on actually scoring that huge moral victory. It confirms that the effort is worth it. And you can never predict when the opportunity will present that will turn things around and that the unimaginable will suddenly become imaginable. But certainly for me this year, one of the highlights of the year was meeting up again with John in Canberra the night that Julian flew back in. And I think that there was a couple of other people here who probably made it down as well. And it really, I think, speaks to the strength of what we can do and our recognition of who we are as a country and a people, and the fact that the effort is all worth it to support people who are in the position that Julian was in or the position that David McBride is in now. So please do encourage people to support that appeal in any way you can, and please do look up our resources and continue to spread the word about the importance of getting this area of law reform right. So thank you very much.
We've got about 5 or 10 minutes worth of questions if you'd like to ask anything from the audience for any of the three lovely gentlemen sitting here.
My name's Jan. I could talk about a number of issues, but 2 days ago, I think it might have even been yesterday, I was listening to National Parliament, and there were moves afoot to bring about new legislation that would appoint a commissioner to look into misinformation and disinformation laws, which on the surface sound pretty reasonable. Obviously, there's been a lot of commentary about what goes on in social media, about all sorts of extreme views that are being put. However, it was canvassed by several of the politicians on the opposite side that were arguing that particularly whistleblowers are likely to be affected by this legislation if it's passed, which it looks like it may already have come through. But the idea of this commissioner would be that the commissioner would have the sole right and responsibility to determine what is mis or disinformation. Yeah, so the question, is does that impact, and have you canvassed and looked into this as well to see how that's going to impact, because it looks as though that could actually counteract in the negative if they can investigate and fine and silence people who are trying to make a reasonable point. Thank you.
The disinformation legislation gives the power to ACMA, the Australian Communication and Media Authority, to either approve standards for social media bodies, if they have one, as to how they deal with misinformation or disinformation, or if the body doesn't have one, to impose one. So it's not quite the situation that some government authority is going to sit there and decide this, although what they are doing is setting the standard which will result in what that is determined. We in the Council for Civil Liberties have put a submission in relation to this which we have opposed on free speech grounds, at least its current model. I mean, a large part of it is to argue that if the things that are bad on social media are bad, then they should be the subject of general laws which already exist, so that you can't go around the place, for example, inciting violence or those sort of matters. How that would interact with these sort of laws, given what I've just said, I actually don't think it would, because it's not about this. Those laws are about regulating Facebook, Twitter, X, whatever you want to call it these days, and all of those things, and setting standards. Although, as I say, the ultimate determiner of those standards will be Australian Communications and Media Authority, otherwise called ACMA. So in the end, they will set the standards, and I mean, in our submission, we argue that, of course, everybody will end up with the lowest common denominator about what is acceptable speech, which is, in our view, a problem. But that's completely another debate. But to answer your specific question, I don't think these laws have very much to say about whistleblowing, because they're not about that. I mean, they're about regulating what goes on social media. So, whistleblowers don't just appear on social media. So I don't think that's necessarily a problem. Anybody else comment on that?
No, I'm good.
Oh.
I'm good.
Hello, my name's Joe, and what I'm concerned about is the notion of what I think are called national secrets, or they're things that one can't say because the government is saying, well, or the military is saying, no, this is that is national secret the right term to be using to describe that? That'll do for the moment, anyway. Yes. Mm. Now, it seems to me that a national secret is something that is declared by the powers that be, that it is a national secret, and that it can't be questioned because that would be a breach of the. So essentially, provided they can say whatever they want, and have it be declared as a national secret, and it can't be questioned. Do I have an understanding of what a national secret is? Is something that somebody high up said is a national secret, and it can't be questioned.
I mean, this is really the nub of the problem. It's not all that sort of black and white in a negative sense, in that there's there's a range of fairly familiar criteria for the types of information where the presumption is that it's not going to be in the public interest to release it, but it'll damage relations with a foreign government, or it'll include it in the definition of intelligence information which is like national secret, national intelligence information that's part of the carve out of the Public Interest Disclosure Act that's affected David. There are sort of legitimate criteria about revealing information about defence operations, or things where there's a clear and obvious risk of harm to national security, or to defence, or to individual personnel, or to sources of information, confidential sources of information, where you can say, yeah, well, chances are that's not going to be something that should be revealed, and it's a sort of objective. It makes sense. But the trouble is when there is the facility for people in government to be able to apply much more blanket categories, and that they're not challengeable, or it's very difficult to challenge them, and that's a real problem in the system. The definition of intelligence information currently means that it doesn't matter what the information is, doesn't matter what the risk is to anybody, or if there's no risk of any harm to anybody from that information being disclosed. If it's ever been in the possession of an intelligence agency, doesn't matter if it's not secret at all, if it's even just been in the possession of an intelligence agency, then it's automatically intelligence information. It doesn't matter what it is. So it's really quite ridiculous. If you blew the whistle on procurement fraud in a national security agency or in defence, something that's got nothing to do with defence or national security, just on people stealing pencils, then it would still be intelligence information because it's information that's within the intelligence agency. So it's just, that's problem number one, is just the breadth of that. But there is a more general problem that the government is, especially the federal government, is that there's an established entitlement under the law to claim that information is, according to the government's say-so, going to do such damage to the government's interests and to the national interest and to relations with foreign governments or to defence operations that it can just assert a blanket immunity for that information, and therefore pull it out of being able to be used in any trial or in any legal proceedings, and it's very, very difficult to challenge it. So those are some of the reasons why those carve-outs have to be removed, and why it has to be clear that matters can be challenged in a court of law, so that people can have their day in court and have their fair day in court. And that's currently not the way our laws are operating, and there are just too many. I mean, there was even a battle that was fought all the way to the High Court as to whether parts of the McBride trial should be held in secret or not, because the judge was saying, well, it was agreeing to applications that said that the National Security Information Act meant that basically it had to be a closed court, and that there could be no open justice. And they were some of those procedural motions were. Those decisions were appealed all the way to the High Court and overturned. So it's a real area for concern, where basically the government can use laws like that to prevent people from having a fair day in court. And until that's addressed much more systemically, then we'll continue to have some of these sorts of battles about how easily the laws are subverted.
Can I just say a couple of things about that? Those of you who may have been at the last event about this, of course, Terry O'Gorman spoke about the whole national information security legislation, and of course one of the reasons why David McBride gave up is because the court ruled that he couldn't put in all this evidence.
That included me as an expert witness.
So these laws are extraordinary, and they're all over the place now, because they're sort of the bikie legislation, they're spreading all over the place, which from our point of view as civil libertarians is very, very worrying, because it just means you can't have a fair trial, because the government stands up and says it's national security information, therefore you can't see it. But the extraordinary thing about this, I always think about this, particularly in this country, is, and I referenced it when I was talking earlier, quite often in my lifetime anyway, the Australian government has stood up and said it's a state secret, and then some American bureaucrat has stood up and said, and answered the question from some journalist and said, oh no, of course A, B, C and D is the case. We are extraordinarily secretive. But in addition to that, there have been a number of reports that have come out in America, published by high-ranking characters in the American defence and intelligence operation, who say that they are excessively secret. So given that these people are, people who are former secretaries of state, secretaries of defence, not your left-wing types at all, think that they are excessively secret, when we get a lot of information about things because some American bureaucrat answers the question, just tells you how broad these things are in this country, and it's just extraordinary. And it becomes particularly worrying when, as an accused person like David McBride, the Commonwealth government stands up and says, you can't have that, and effectively kills his defence. And the same things were being argued, as you might recall, by Bernard Cleary, who was the only one of these people who, for whatever reason, thankfully for him, has been, the prosecution has been stopped. But he was facing the same problem, trying to defend himself, because they were just standing. And we had, the Council for Civil Liberties had Bernard as our, give a talk a couple of years ago after he got released effectively, where he was saying that not only were his lawyers excluded, he was excluded. The people from the prosecutions were excluded, and all these people who turned up from ASIO or whatever were the only people who appeared before the judge to argue about whether or not this information should be disclosed, not only to the court, but to the prosecution and the defence. It's extraordinary.
Thank you.
My name's Alex. To me, it feels like the inadequate whistleblower laws come in a context of, I guess, general erosion of democratic rights. And I guess I'm aware that the Human Rights Law Centre released a report recently about protests in peril, so all the anti-protest laws that have happened over the last several decades. We've also got 2 decades of anti-terror laws, and also just things like this week the New South Wales government's tried to clamp down on the rising tide protests in Newcastle coming up in a week or two, and other, I guess, like broader sort of attacks on democratic rights. And I guess I'm also very aware that oftentimes, like the case with Julian, obviously you need to have like a legal part of the campaign, but you also need to have an activist part of the campaign. So I guess I'm wondering, from any of the lawyers on the panel, if you wanted to talk about how can activists or campaigners help out in the sort of legal defence of those sort of democratic rights in that sort of broader context, and also if John wanted to make the comment from the campaigning point of view.
Well, so the short answer to that is, we as lawyers can only deal with the law as it is. So when the law needs to be changed, people need to be active in campaigns, as you are this evening. I mean, we have now Queensland Human Rights Act, which does give greater scope. It hasn't been used a lot so far, but I think a lot of lawyers, quite frankly, don't understand its importance. So there is more opportunity for people to run these arguments, but ultimately, we as lawyers can just turn up and use the tools that we have, and we have some wins and we have some losses, but ultimately, the law is determined by public opinion, and people have to be prepared to go out there and campaign for the laws to be changed, which is what we're talking about in terms of whistleblower laws and all that sort of thing.
AJ?
Yeah, I mean, the only thing I would say as somebody who is and has been a bit of an activist as well as a lawyer, is to not let your knowledge or your, if you feel you have a lack of knowledge of the legal technicalities of what's going on, get in the way of your gut feeling about what is right and what is wrong, and be motivated by that, because you can be quite confident that your gut feeling about what's right and what's wrong on these issues is probably pretty right. And I think that's the key thing. In fact, I think, Alex, you're connecting this with broader democratic freedoms is really quite right. As long as this is just a game of sort of legal cat and mouse, we will have all of these problems with these technicalities and these carve-outs being used to defeat the intention of the legislation. And there is a real question about how we can get the fundamental right and obligation, duty of people to speak up about wrongdoing properly protected in more fundamental ways in our legal system. It does link to the lack of effective statutory and constitutional protection for fundamental rights. And the interesting thing about whistleblowing and speaking up about wrongdoing is that it's not just a right, it's not just a free speech right, it's actually a social obligation and an organisational obligation, and often an employment obligation for people to do that, which just triples the injustice, because people are actually doing what they're expected to do by speaking up about the wrongdoing. So then it makes it even more unjust that they then suffer consequences, because they're not actually doing it just because they love free speech. They're actually doing it because they're fulfilling a sense of, they're fulfilling all sorts of things, but fundamentally they're doing something which we know is fundamentally important to society and for society, and we would never be able to function as a society if it was not for people speaking up internally and externally about wrongdoing. So I think it really is important to go with your gut feeling about what's right and wrong, and transmit that message to other people. Don't get hung up on the legal technicalities. Leave the legal technicalities to the lawyers. Unfortunately, there's some very good lawyers around who are working on these things, including our colleagues in the Human Rights Law Centre, who I think you mentioned, who are very good friends and colleagues and compatriots of ours in all of this campaign.
Thank you. We'll just take 5 minutes, no more, sort of running a little bit behind, and then we'll get John Shipton up and listen to what he has to say. And now, to introduce our main speaker, the most wonderful and amazing John Shipton, who's just returned from Russia.
All these faces that we've been at the barricades forever, you know. First, a little bit of housekeeping. We have the Order of Australia to give to Graham Dunstan. Now, I'm calling it the Order of Admiration for 30 years on the trail of bringing to us these and starting the counterculture in Nimbin. Thanks, Graham. Policy, policy, policy. Keep that mantra in mind. Policy. Keep the policy word in mind and that mantra in mind. And together we can look at something. We can go on a journey. In 1988, the Soviet Union withdrew from Afghanistan. 1991, the Soviet Union stopped paying the subsidies to Afghanistan and the Afghanistani government collapsed. By 1995, Afghanistan was the world's largest producer of heroin, opium. So they grew the opium and they had the labs to convert, the factories to convert it into heroin. 1995, the CIS states, that's the USSR and several other states, had no use of heroin whatsoever or opiates. By 1997, 70 tons per annum were coming into the Soviet Union, or the Russian Federation as it then became. 70 tons per annum within 2 years. How did that came about? The deputy director of the CIA, in association with the Georgian mafias, worked out a methodology that they together would appoint people to what they call oblast councils, appoint their own people, and this facilitated the distribution of heroin in the Russian Federation. 1996, the Taliban burst onto the scene. Taliban means student. They were very much again debauching of the youth of Iran, their own youth, the youth of the Russian Federation and Pakistan, and corrupting the government officials and institutions of state. So the Taliban moved to destroy all of the warlords that the United States had facilitated with the CIA. The advantage the United States sought and continues to seek is weak state institutions which can't defend the interests of the populaces. They do it over and over and over again. They call it colour revolutions or such things as that. These are well studied and well understood. It is policy of the United States empire to debauch the youth of Iran, the Russian Federation, the Afghanistan and Pakistan and to a certain extent India, where they had the power, to debauch the youth of those countries and to shatter the institutions of state which protect and organise to keep those communities in the flow of benefits to the families and communities therein. Really important. It's policy. Upon that rotten foundation, as the Taliban became more successful in the repression of opiates, repression of opium growing, as they became more successful, the United States saw that its opportunity to make money and debauch those countries that I have mentioned, retreating from it. They were losing the war to keep the opium fields at 90% because of the Taliban resisting and destroying the warlords. So they invaded. Opium production rose again to 90%. Last week I was reading a UN report on the present cultivation of opium in Afghanistan is now 12%. Somewhere we can see the outlines of policy. The Australians there, the soldiers, are expected to be honourable men, men of honour, upon the most rotten foundation that a human being can imagine committing to. Policy. The Australian government must be aware, because it's in Five Eyes, of the circumstances of heroin production and the money making that it encounters in Afghanistan before we assisted. Policy, state policy. A white knight emerges from that decay, David McBride, and he sees things as a lawyer does, not as I am speaking to at the moment, of state interest and state strategy and state policy. He sees this and he objects to it and makes the point in reports, and eventually feels that he has to make public his understanding of what is happening. The Brereton report supports his conclusions and says that it's likely there's 39 murders. Well, if you read the Afghan war files, they're on WikiLeaks. I was just reading them a minute ago to look up an example to give you. There are hundreds of thousands of civilians' deaths. Now, what is a civilian? What does that word cover and embrace? Mums, dads, grandfathers, grandmothers, aunties, uncles, babies, children, toddlers. That's what that word encounters. 200,000 civilian deaths. 200,000 mums, dads, kiddies, aunties, uncles. And we were involved in that fundamental crime for 20 years. Policy, state policy. It is to Australia's advantage, so the state policy goes, but they won't announce it to us. We only have to discern it from the patterns of behaviour. What happens is the clue. I might say, by their deeds you shall know them. The state institutions of Australia think it's to the advantage to be engaged with the United States in the occupation of Afghanistan, an ongoing 20-year crime that they simply abandoned. And now our courts, in dealing with David McBride, enact state interests. Mossop enacts state interests because they do not want the examination of public interest in the hearings. AJ was one of the witnesses to be called. They do not want us to know, to work the patterns. It doesn't have to be direct information. To work out the patterns of state interests being enacted. It was under Julia Gillard, who said Julian should be locked up, that the first Australian deaths happened in Afghanistan. So we sacrificed the lives of our soldiers for a state interest which was founded on the most rotten circumstances you can possibly imagine for human beings to act upon. That's the circumstance. Take it into your heart and examine it. And that way, it will precipitate action. You'll speak to each other. You'll become witness. And as in the case of Assange, we all witnessed throughout Australia. And the state policies had to adjust themselves in order to accommodate the growth of knowledge in the community. It's comforting, of course, to think that our father, the government, or our mother, the government, acts in our interests. No doubt they think they do. But institutions are like human beings or trees. They grow, they decay, they renew. And it's pursuant upon us to understand that the institutions aren't creations of God. They're creations of man. And as a consequence of that, they have their trajectory. And sometimes it's good, and sometimes it's not so good. We have the capacity to ensure that those institutions of state face reform and act clearly in our interests and resist, in one way or another, cunning, guile, resist the implications of the United States to weaken our state institutions and keep us dependent upon the United States for the defence of this wonderful territory. Don't do it. That's what we say to them. Don't follow the Washington consensus and give up your industrial base. In an industrial scientific society, you need engineering knowledge as a strata, a living strata in the community. And you only get that by doing stuff. You don't get it by sitting in a design studio. It's a vertical integration of the efforts of many men and women to produce good institutions which understand in their nature the necessity to have an industrial base for Australia in order to have the knowledge to defend ourselves. The last point I'll make, there's it's like pulling a snake out of a hole, you just keep on pulling it endless. AUKUS, $358 billion. A direct plundering of our treasury. Okay. An appalling sum of money. A worrisome sum of money. What's it about? Well, They say it's Virginia-class submarines, a nuclear-powered submarine which uses plutonium, so weapons-grade uranium to drive it. Okay. It's a platform for a weapons system called cruise missiles. We're paying $358 billion for 8. Russia, the Russian Federation, makes 8 Virginia-class submarines, they call them Yasm class, 8 for $9 billion. Where's this money going? Who's whacking up this loot? If we have to pay tribute, let's say, okay, we have to pay tribute to the United States for its protection, and we're going to work our way out of that circumstance. Cruise missiles, they're obsolete. The Yasm class has 2 sets of missiles. They're both hypersonic missiles. The Kinzhal travels at 9 times the speed of sound, and the Zircon 13 times the speed of sound. An obsolete weapons platform, $358 billion, a gross overcharge, which we will never ever get. The United States, in its own submarine production facilities, is 6 years behind in their own manufacturing system. 6 years behind already. That doesn't count our 8. It'll never happen. We will never, as a consequence of this cunning of the United States to keep us defenceless and to be able to continue to plunder us, like they plundered Germany, France, Canada, New Zealand, Australia. It's just plunder. But if we can face the truth of that's the circumstances of the hegemon, then we can work our way out of it. We have an understanding that the $358 billion is partially or completely a tribute that we have to pay to the United States to so-called protect us. In other words, a mafia arrangement. How you work your way out of this is the same way, we successfully brought Julian home. Take the information that's around and convert it to knowledge. This builds the body of knowledge in our community, and a healthy community acts upon what it knows. Sometimes the mother of Gabrielle, one of my children, says, "Oh, John, why don't you just go and do this?" And I think to myself, but the stimulus of knowing, the stimulus of knowledge, it's really healthy. Anyway, I hope I haven't been overstrong this evening, but I just wanted to grasp the fact that it is policy, and that Mossop's decision not to allow public review in the public interest is an act of state interests founded upon 20 years of occupation of Afghanistan, based upon the capacity of Afghanistan to produce opium and heroin and consequently debauch the youth of its neighbours. That's what they want to conceal from us. And that's what David's release has hinted at for us. And this has now become a knowledge, and we can act together, hand in hand. Just over dinner, have the conversation. And it becomes knowledge. The information then becomes knowledge as we sort it through each other's intelligences. You know, I didn't start out with these insights. I learnt from people here over the years in conversation and over the last 15 years of how these states go about their state interests. Anyway, good luck. Thank you.
Would anybody like to ask John any questions? Just come up the front, please.
G'day, John.
Yeah,
I was sitting
g'day.
around
How
the
you
traps a bit. Yeah. Okay, so 300 and something billion for the subs. How much have they already get in the infrastructure in case? And how many hundred billions would you need to staff the things if we ever got it? It's more than just 300 billion for subs. It's anyhow, that's all. Thank you.
Thank you. Anybody else?
Well, I've written a lot on the heroin trade. In fact, my best academic paper was Australian heroin seizures and the causes of the 2001 heroin shortage. The heroin trade, the opium trade, follows US wars across Asia. When the Vietnam War was happening, 70% of the opium production was coming from the Golden Triangle then. And when that war closed down, it took over in sort of Afghanistan and Pakistan. And that was the cause of the heroin shortage of 2001 was the Taliban closing down opium production in Afghanistan. And after that, after the US invasion, Afghanistan got up to 93% of world opium production, and just recently the Taliban's again closed down opium production in Afghanistan. It's interesting that the Pakistani CIA were involved with that through at that period, and they've been involved in overthrowing Imran Khan as president of Pakistan. I haven't really found out much about that, but that's very interesting too, because Imran Khan, who was the great Pakistani all-rounder, became president, and then he was something like a lawfare thing happened with him, and he was being imprisoned and he's still there. So yeah, what happens is they just want organised crime. They made a deal with the mafia during the Second World War, and they made a deal with Sydney's organised crime in the 1970s, and the reason why my email account is called The Sydney Connection is because I wrote a book called The Sydney Connection about that, about how when the Vietnam War finished, they just redirected the world heroin trade through Australia. So yeah, what John's saying is true. I mean, and I totally agree with you, John, and that's what they are. They are a criminal organisation. When you say they're like the mafia, they include the mafia, and they include what I call the Oca Nostra, which is the Australian mafia, because it's based on, Australians. It isn't just Italians. Italians are part of it. All the immigration are part of it, and so is also what was called the Hungarian mafia. So, I think it's an important point to recognise that, and that's been fairly well known since about I say fairly well known. It's always suppressed, but since the 1970s, when the information came out about how they were running, CIA was running various secret operations in Indochina, as it was called in Laos, Cambodia, that the president and the vice president's wives of South Vietnam were involved in the heroin trade. So it's really deep, the connection between the deep state and the drug trade. And it's something that you won't get in the mainstream media, but the mainstream media is just full of lies. Anyway, that's not really a question, John. Yeah.
John. That was really informative.
Right, thanks, Imogen. Just a question to you, John. You just recently come back from Kazan. What was your impression and what was the atmosphere like of such an event?
Good question. I got so wrapped up in this thing. Look, it was wonderful. There were 35 nations there, 20,000 delegates, 2,000 journalists locked in the cage, they called it the cage, where they worked. They treated me really well. The interviews that I did were done were by accident. You know, I was just walking along the street in Kazan, looking at the Kremlin. They have their own Kremlin, which is very beautiful, and it has the tone of Tibet in its architecture. It's very beautiful. I just can recommend, you know, if you go to Moscow or St. Petersburg, they're fantastic. I walked my legs off in Moscow. I didn't see one beggar, not one. Nobody sleeping in doorways, anything. A really dynamic city. As for BRICS itself, they're about 38% of the world GDP. The G7 are about 28 or a little bit more, going downwards. Germany's GDP only increased by 0.2. That's 0.2 last year, and it's going to get worse. They're closing factories every week. The BRICS, they established a few things which are really interesting. MBridge is a payment system, BRICS Bridge, another payment system, and BRICS Pay, which is like a Visa card, you know, it's issued to everybody in those countries. Just to, you know, round it off, to give you a feeling, it is ascending life. It is a new thing appearing with a lot of vigour. It's ascending life. When you look at the United States, you can clearly see that they're in a lot of trouble. 40 trillion of debts to service, you know. Their debt servicing figure this year is $880 billion. $880 billion just to service debt. The circumstances in the Department of Defence, it's now 2 years since they've made their contribution to the retirement fund of the soldiers. That tells you something, doesn't it? 2 years and they're not paying their soldiers into the soldiers' retirement fund. So the fund itself is constantly declining, being drawn upon. 500, I've got to search my memory here, but I think it's $250 billion of the budget is paid out a year to retirement benefits and damage benefits to veterans. The place is a terrible mess. I've been there, travelled across it. I'll tell you a funny story before. We did the Ithaca movie, and we're in this New Hampshire, and in a building about this size and about twice this number turned up for the film. And all the men came in carrying guns to a movie. And I said, oh, you know, you guys carry guns. Yeah, open carry. And I said to the woman standing next to me, this American woman, gee, you must feel safe. Everybody, you know, is tooled up. And she said, we look after ourselves.
Well, you keep holding it. I've got another question for you.
Okay, John, in Washington at the moment there's a phrase that's flying around, and that is that personnel is policy. Now, over here in Australia, we've had Senator David Shoebridge asking if there was concern now that Donald Trump is the commander-in-chief within the context of AUKUS. Could Donald Trump be our exit from AUKUS?
You may remember from when Donald was in his first presidency, early on when he didn't have so many troubles, but travelled to Europe and said, look, you guys have got to have, all of you, 2% to 4% of your GDP spent on defence. In other words, another Mafia Act. I don't think Donald will be, engaged in reducing our necessity to pay $358 billion. He'll probably say, you've got to spend at least 4% of your GDP on defence.
With regards to David McBride, he wasn't, he's exposing the war crimes, but he really wanted the culture of the perpetuation of those crimes and the heads to roll at the top, including right up to the Governor-General. And I know a lot of people might think, well, that war's over there and maybe Australia's not so affected and, we're the good guys. But, in my circumstances, he serves 2 terms in Afghanistan, like David McBride. And out of his little squad or division or troop, I'm not sure, anyway, it wouldn't be a division, but small. He's the only one left. Like, some were killed over there, but most of them suicided back home. And I don't know, I haven't got a question, I just wanted to know if you want to comment on that.
Yes. Well, the tragedy doesn't stop. It comes home to us in soldiers who are knocked around, and the mentality is unsuitable to look after families and women and so on. We know that. We've known it for many, many centuries. My father came back from Kokoda in North Africa, and he couldn't bear people crying, so he was given a job as an insurance consultant. So he'd go around. It's dreadful. He'd go around to the widows, and they would say, "Oh my, I got," and he'd start laughing, because in his 6 years of warfare, that's the dreadful circumstances had that reaction on him. As for, look, I just want to do a lot of work for David, but I'm not going to place him in contention with the upper echelons of state administration. There will be a sacrifice. Either they'll sacrifice the Governor-General and get another one, it'll be silent, he'll be gone. That's how they'll handle it. Or they'll sacrifice David. In this case, it was David. So you can't take on the state. What the formulation for David that I run with is that David is an assisting the state in an area that needs reform and attention. And you do that by way of examining the circumstances, okay? But you don't go hard against the state always wins. You might remember in the years that we were campaigning, I always praised the states. I said that the people have gathered together and their representatives in Parliament have taken notice of them. The Parliament, acting as the Parliament, instructs the executive to rectify the circumstances that is causing the populace concern. Okay, that means I fit like a glove into the way the government of Australia, the institutions of state, prefer to be seen. It engenders warmth. And that's how we did it all over the world. In England, we praised them mightily for the origination of a fundamental document which places the law between the individual and the state. a shield for the individual. It's called the Magna Carta. In the United States, we hammered that every single person in the United States, in the air they breathe from babyhood, includes the First Amendment. And we hammered that. In France, we hammered the fact that France was first in the queue to make legislation of human rights, and so on. So you can't go against these institutions. You just become a comic figure. Oh, it's no good. So you use guile and wit, and you seduce with your mind. Anyway, you get the point. I just won't make. They're not our enemies. You know, I don't want us to think of, you know, they're people in institutions take upon the ideology of the institutions. Otherwise, they get pushed out. They're called mavericks. So an institution requires that. Also, institutions exist in competition with each other. So consequently, they push to the top that group or echelon or cadre or cohort that can successfully compete for them. We are the same, except we have a lot more freedom. We have, you know, freedom to, well, actually we do have an ideology that embraces us all, but it's fairly loose. And we hunger for justice and absolutely reviled and repulsed at the sight of injustice and cruelty. You know, when I look at those videos of the little kids, a boy coming home in Gaza into the hospital with his backpack on. The doctor says, "What have you got in the backpack?" And my sister. I don't put up with that. I'm not going to put up with that. I don't think you should either.